to give a basic introduction, the first few cases that I'm going to talk, the case law that I'm going to talk about, are going to focus on the importance of procedural prudence. And Lee can tell you, as the expert that he is, in the job that he does on a day-to-day basis, that procedural prudence is the key under ERISA. ERISA is really a procedural statute. It doesn't tell you what results you have to have, although sometimes in litigation it feels like that's what has to happen. ERISA just sets forth a series of procedural requirements that ERISA fiduciaries should follow in order to comply with ERISA's requirements. And on the first page of our presentation here, we talk about a few of those that will be illustrated by the cases that I go into after this first introductory slide. Just focusing on a few of those procedural requirements, the plan documents must be in writing. And as Lee can tell you, and I will tell you, if you are an ERISA fiduciary, you should read the document. You should understand the document, not only the plan document, but the trust agreement. Also, plan administrators must comply with certain disclosure requirements to the plan participants, and they're set forth in ERISA, and there are certain requirements that if you get a request from a participant and you're a plan administrator, you have 30 days to respond, and if you don't, you could get a penalty, a daily penalty, if you don't comply with that requirement. Plan fiduciaries must be named, and they have to act prudently and exclusively in the best interests of ERISA participants and beneficiaries. Prudence is, I think, best demonstrated by a robust, contemporary, written record of thoughtful deliberations and careful and unhurried actions. Lee, do you have anything to add on that first section there? I'm just going to say a couple of more words and then get right into the cases.
The one thing I would like to point out is that one thing I see a lot as an expert is that you'll see minutes of investment committee meetings that are recorded poorly, and that causes all kinds of problems afterwards. So it's certainly worthwhile to take the time to review the investment committee minutes and make sure they properly record what happened.
I agree with Lee. That's a great comment. And Lee, as you'll see and as you've seen, the case law, the courts really hit hard on the folks who don't have good, thorough, contemporaneous record of their thoughtful deliberations on their ERISA fiduciary determinations, and that's I think the difference between winning and losing in many of the cases. The Department of Labor, the U.S. Department of Labor, Secretary of Labor, is charged with enforcement of ERISA, and under Section 502A of ERISA, plan participants and beneficiaries also can bring lawsuits to enforce their ERISA rights. And again, as you'll see from the series of cases that I start with in the beginning here, procedural prudence is the key to success.